Good morning, everyone. Thank you for joining us. My name is Nahliah Webber. I'm the Executive Director of the Orleans Public Education Network, where we do policy advocacy and work with families and communities to fight for equity and excellence in our public schools. As part of our initiative for Public Education Week, we are being joined by wonderful community advocates, experts that are going to help all of us understand this public education system, how to navigate and advocate within it. Today, we are joined by Victor Jones, senior attorney. Is that your title, senior attorney at the Southern
Sure.
at the Southern Poverty Law Center here in Louisiana. And he is taking time out of his busy schedule to come and talk to us about what parents and students' rights are in the school discipline process. So I'm really excited to have this conversation, and I'm really excited that this information is going to be brought to a lot of parents and families who may not know. So Victor, if you just want to introduce yourself and your work, and then we're just going to jump into the conversation.
Absolutely. Well, thank you again, Nahliah, for having me. As the senior supervising attorney at SPLC, I lead through litigation, public education, and public policy, the children's rights team, as we address three priority areas, and that's stopping the school to prison pipeline, which much of our school discipline work comes from that area.
Mhm.
And promoting education equity and access to mental health services. And just a quick demonstrative as to why those three relate to one another.
Mhm.
Often we have students who are disabled who are more likely to be subjected to these exclusionary discipline practices that I will talk about.
Mhm.
And if that student isn't receiving the proper special education or general education, so that would be education equity, and if that student has an emotional or behavioral disorder, which over 200,000 students in Louisiana do,
Mhm.
um, if they're not receiving proper access to mental health services, then they are more likely to languish in school and be subjected to, um, again, having behavioral problems and then becoming a part of the school to prison pipeline. So it's hard to even talk about this work without mentioning those other three areas because they all do relate.
Yeah, yeah. Thank you for that. We actually had a panel last night. It was hosted by Dr. Torrance Sanders around
Hmm.
how to support our Black boys in public schools to be successful, and that came up a lot. Um,
Hmm.
not all of our Black boys are traumatized, but trauma is something that a lot of children in New Orleans in particular are dealing with and trying to manage. Is manifesting in terms of behaviors in the classroom.
Hmm.
And we're seeing more Black boys being, identified for need of special education services, but also in those very subjective categories
Yes.
around behavior and also placement, which is leading a lot of them to being kind of like, they're they're becoming disinterested and disengaged and detached from
Hmm.
school because
Yep.
it's a place that for a lot of students, it's a place that doesn't mitigate that trauma. It's
Hmm.
sometimes a place that perpetuates it and even exacerbates it.
That's right.
So, yes, so thank you for that. And we're just going to get right into it. So you said that your focus is on these exclusionary discipline practices. Can you explain what those are and what those look like?
Okay. So when we say exclusionary discipline practices, we mean any disciplinary practice that removes a student from their classroom and from the general education setting. So that would be in school and out of school suspensions. That would be expulsions. That will be unilateral transfers to alternative schools.
Mhm.
Um, we know just from the data that we have received from the State Department of Ed that students who are disabled and Black students are more likely to be subjected to these exclusionary discipline practices. And when we try to figure out the why behind that, oftentimes we come across in our work at SPLC the issue of the absence of due process
Mhm.
before those students are subjected to discipline. And I'll talk about that in a little bit. But the reason why, just from a practical standpoint, why it's detrimental to remove a student from the classroom is quite obvious. They miss out on instructional time. The student also misses out on learning in an environment with their peers, which is very important in terms of academic success. And so schools are, a trauma-informed school. I know we play with that word sometimes, I feel like, but a true trauma-informed school is doing everything in their power to ensure that students remain in the classroom and that targeted interventions are put in place um, to prevent students from having to be removed from a classroom setting. And so what we do is we monitor school districts that do have a high number of these exclusionary discipline practices. This also gives me the opportunity when we talk about, how do we know which schools are disciplining at a higher rate? That gives me a great opportunity to talk about House Bill 160, which is now Act 148. Effective August 1st, all Louisiana public schools, including schools that are housed within the Office of Juvenile Justice, have to collect data on the number of students who are suspended, expelled, or unilaterally transferred to an alternative school. And that data has to be disaggregated by race, by sex, by disability status, as well as by ELL status, English language learner status. And so we anticipate receiving that data no later than August 1st of 2020 for this past school year. And once we look at the data, we'll start to notice trends in terms of which school districts are engaging in these practices. One really quick addendum to suspensions, and that's silent suspensions. We have to talk about that very briefly. Silent suspensions occur quite often. And that is when a student isn't formally suspended. It could be as simple as someone from a school calling a parent saying, you need to come and pick your child up for the rest of the day. They may go home and cool off. Do know that the due process rights that we're about to mention are attached to silent suspensions. And also, as parents, you should never allow a suspension to occur. If a school is asking you to come and pick your child up, as I go and grab my charger, if the school is,
it allows for life to happen while you're doing your thing.
Right. If the school district is asking you to come and pick your child up, then you need to demand that there be documentation and that ask is documented as a suspension. A lot of times you have school districts who will report at the end of the year that they've had no suspensions. Because we definitely got 2 RFAs, requests for assistance, from your school saying that, you were suspending a student and that student didn't have a due process hearing. So we do want to, as parents and advocates, monitor those silent suspensions, make sure, send your child home so that they can cool off for the rest of the day and they can come back tomorrow or next week or however many other days. Those are deserving of due process protections as well.
Right. Thank you for that. It's a couple of things that I want to bring up here. So first, thank you for that language, silent suspensions. This is the first time I'm actually hearing that. I always called them like informal suspensions, right? Yeah. But I like silent suspensions, and I like that you gave the language because, oftentimes folks don't have the language to describe their experience. And without that language, it becomes difficult to then advocate for your child, right? That happens quite a bit. Or I've been in schools where the dean would drop the child off at home in the middle of the day.
Wow.
Right? Like, call an Uber and take the child to the parent's house. And there's really nothing that a parent thinks that they can do about that. They think that it's a par for the course and their child is acting up, and so this is fine. Or that they may even think that that's better than a formal suspension, right? At least it's not a child's record.
Yep.
And
one more thing to flag, I'm sorry, bus suspensions as well. Bus suspensions are regular suspensions. If you are told that your child cannot ride a bus because of some infraction that's occurred, that
Mhm,
needs to be documented and classified as a suspension as well.
mhm,
There are due process rights equally attached to bus suspensions as
mhm.
they are to silent suspensions or any other form of suspension. I think that's important to mention
Right.
because we recently came across a school district in Northeast Louisiana that was on paper, they were not suspending in school, but they were doing a massive amount of bus suspensions.
Mm,
If you think about it, you know,
it's the
if you
same
are
thing.
suspended from the bus, you're not going to school. That's a suspension,
Right.
right? For a lot of children. So also be mindful of bus suspensions as well. Sorry, I had to throw that in
No, no, no. Thank you for that as well. I mean, often that's the case, right? I'm
there.
on the
Hmm.
bus because this is my only mode of transportation to school. So when you
Hmm.
cut me out of the bus, you're actually cutting me out of access to
That's
my
right.
education.
Yep.
I want to talk about a little bit about HB 160 and why that's important because schools already report this data, right? They're supposed to.
Hmm.
Why was it important to get Act 148, HB 160 in place, with, even though schools were already reporting this? What were some of the gaps there that this act addresses?
So three reasons. One, there was a temporal gap, meaning the school districts were only reporting the data every other year because that's what federal law requires, right? So the CRDC data collection, the Civil Rights Data Collection,
Hmm.
only requires that this data be collected every other year.
Okay.
Now, the Every Student Succeeds Act, ESSA,
Hmm.
requires that the data be collected and reported annually.
Okay.
So what we had going on in Louisiana was that data would be reported every other year to the CRDC,
Hmm.
and only suspensions and expulsions were reported yearly to the general public.
Right.
And so if you were to go on LDOE's website right now, for example, you can find the number of students who were suspended and expelled, disaggregated. No, actually, not even disaggregated. You'll
Mhm.
find the total number of students suspended and expelled, right?
Right.
And so we had a couple of pieces of information missing. It's like, all right, well, under ESSA, not only are we supposed to have the suspension and expulsion data, we're supposed to have the school based arrest data, the unilateral transfer to alternative school data. We're also supposed to have that data disaggregated by race, sex, disability status, and ELL status. And we didn't have that. And the only of those four categories, the only data that was available yearly was, again, the suspension and expulsion data. Right now, if you were to go on LDOE's website, you would not find any data on, for example, school-based arrests and referrals to law enforcement, or unilateral transfers to alternative schools. It's not publicly available.
Mhm.
And so we realized that in the course of having to send, you know, ad nauseum levels of public records requests to
Mhm.
school districts for information that should be publicly available anyway.
Right, right. And I'm going to ask another question that might be a segue into the next. It may not. But when you're talking about exclusionary discipline practices, does this also cover policies, particularly cultural policies in schools, that would bar a child from attending? So, for example, a hairstyle policy or a uniform policy. Does it also
Yes,
include that as well?
yes, it does.
Okay.
Hmm. And the way that those policies usually come into play, we would classify those as silent forms of suspension, right?
Mm,
If you're telling a student that because of a uniform infraction they can't physically go to class,
right.
then that's considered a suspension of sorts. Yeah,
Hmm.
absolutely.
Good to know. So let's move on to why all of this is important in how these exclusionary discipline practices impact students and families and why they are detrimental to their experiences.
Hmm. So again, the data that we do have,
Mhm.
it shows that there are two groups that are most likely to be targeted by these exclusionary discipline practices, and one is disabled students, and secondly is black students, right?
Mhm.
And so, just going through both categories, we know that it is imperative for a student with a disability to be in class as much as possible, to remain in the general education setting as much as possible. And so when a student with a disability is removed from the classroom setting because of that behavior, which oftentimes, not all the time, but oftentimes is a manifestation of their
Function of their
disability,
disability.
then we're in the realm of now disability discrimination, right? And so just again from a practical standpoint, we don't want to remove disabled students from the general education setting. They need to remain in the general education setting as much as possible so that they can obtain a free and appropriate education like their non-disabled peers.
Mhm.
Now, for Black students, we talk about, just traditional civil rights. When we talk about the selective enforcement of policies and
Mhm.
how they disproportionately impact Black students, school discipline is usually at the very top of that list.
Mhm.
And so there's been all these national studies, for example, about, Black students being more likely to be suspended for uniform infractions than white students
Mhm.
who would commit the same uniform infraction, right? Or
Mhm.
even like to your point about like policies that don't allow students to come into a classroom because of hairstyles. We know that that type of policy more disproportionately targets Black female students than any other group, right?
Mhm.
And so, and if that is the case, if we're creating all of these barriers, if schools are creating all these barriers to access that particularly impacts Black students who have been traditionally marginalized and excluded from the school setting. And
Mhm.
so, what federal law requires is thus: in order for a school district to receive funding from the federal government, it has to make sure that it is abiding by all anti-discrimination laws.
Mhm.
And the way that the federal government is supposed to know whether or not these school districts are abiding by anti-discrimination laws is through data collection and reporting. When we
Mhm.
talk about anti-discrimination laws, we mean Section 504 for students with disabilities. We mean Title 6 of the Civil Rights Act, which is not discriminating on the basis of race, color, or national origin. Title 9, which is for sex discrimination.
Mhm.
And ELL status also ties into Title 6 as well. And so those are the groups that have been traditionally marginalized um, from from participating in a school setting through these disciplinary actions.
Mhm. And what can you tell us in terms of like what the data may be showing in terms of what some of the longer term outcomes are looking like? Like maybe, I don't know, there could be correlation, there could be causation. But when we're seeing these kinds of practices in places in schools, what are we seeing with our graduates or
Yeah.
people matriculating from middle school to high school? Is the data pointing to these practices, for example, in a K through 8 setting, might be leading to these other set of outcomes in ninth through 12th grade or post high school?
Yeah. Well, tragically, these exclusionary discipline practices are what we mean when we say the school to prison pipeline.
Hmm.
When you when data is collected on either juvenile justice involved youth or actually incarcerated adults, if you look
Hmm.
back at their records, an overwhelming majority of them were subjected to disciplinary practices while they were in school, and
Hmm.
oftentimes that that disciplinary practice is their first encounter with police,
Hmm.
right? And so I know in Louisiana, for example, over 70% of juvenile justice involved youth
Wow.
were first subjected to a disciplinary practice in
Wow.
school. That was their first encounter with, the law, quote unquote. And the same thing for the adult population. Again, an overwhelming majority of incarcerated individuals, including individuals who have been incarcerated for nonviolent crimes, their first encounter with police happened, or their first encounter with discipline happened again in the school setting.
Mhm.
And so it's often said when we talk about the school to prison pipeline, what folks really mean in this area is that school is often the first place where these practices begin, and
Mhm.
the end result often, unfortunately, is juvenile just involvement, and for adults, incarceration.
Hmm. Wow. And we won't even get into the percentage of incarcerated adults who may have a disability
Oh
that
my God.
went
Yeah,
unidentified and untreated in
that's
school,
right. That's right. Mhm.
which probably led to a disciplinary referral or action, and then on and
Absolutely.
on. So yes,
Absolutely.
wow, that's a lot. But your work and the work of your team is to make sure, among other things, making sure that people know what their rights are. So you
Hmm.
get a lot of requests from family members, parents, and you also work with other organizations such as Friends and Families of Louisiana's Incarcerated Children and others that are focused on
Hmm.
helping parents support their child that is court involved or involved in the juvenile justice system. But before we even get to a place where our child is involved in that system, what should parents know about their rights, about their children's rights, so that they can push back on some of these things?
Okay. Due process, right? Due process consists of two things: notice and an opportunity to be heard. So think about, I like to use the analogy of when you receive a traffic ticket.
Mhm,
Your ticket, that traffic ticket is your notice that you have committed a traffic violation, right?
mhm,
When you look on the back, there's a hearing date. And that hearing date is your opportunity to be heard, your
mhm.
opportunity to dispute that traffic violation if you see fit to do so.
Right.
Due process is embedded in the notion of American jurisprudence and laws in general.
Mhm,
It's a fundamental part of our American existence. Do you see ways of due process existing in manner that you have no idea about?
mhm.
Even when you are applying to school, right? When you get an application, it lists all of your notice, all of the things you need to know in order to actually apply. And
Right.
then on the back, if you're not admitted to the school, there's an appeals process where you can challenge the decision, and that's your opportunity to be heard. So
Mhm.
due process extends well beyond the legal lexicon. It's again a basic notion in life here.
Right.
Fortunately, as we know,
Right.
again, Black and disabled students are often deprived of their due process. And so rather than get that notice and opportunity to be heard, they are summarily suspended or expelled or transferred to an alternative school when, had they gotten that opportunity to be heard and present their side, it might not have even happened, right?
Mhm.
The discipline may not have even happened. So when we talk about in the context of student discipline, notice and opportunity to be heard, the first thing I tell parents is always read the student handbook.
Mhm.
Every student handbook in the city for the charters should have a section on your rights with regard to discipline.
Mhm.
And what the language usually is something to the effect of, before your child is suspended, um, or before your child is expelled, they have the right to tell their side of the story first.
Okay.
You have the right to be noticed of the basis of the suspension. You have the right to be presented with all of the evidence in support of the disciplinary decision. And so if you get a phone call from a principal or whomever that says, we are suspending your child, the phone call is proper notice.
Mhm.
That's fine. We are suspending your child. The follow-up question on your end needs to be, under what basis? Under what documentary basis? What is your evidence for doing so?
Mhm.
And when you invoke that request, the school has to answer. They should provide it for you anyway. We
Right.
know that that doesn't happen a lot, but they should provide you with that information anyway. We are suspending your child because your student on this date committed this infraction and there were these witnesses, right? And
Mhm.
so that often doesn't happen. And so when you hear that your child, whether it be through a letter or through a phone call, that your child has been suspended or expelled, before those suspensions or expulsions can go into effect, or unilateral transfers to alternative school, before any of these actions can go into effect, you are supposed to be noticed and you're supposed to be given the reasons behind it.
Mhm.
And you, being parent and student, have the opportunity to tell your side of the story and present your case to challenge that decision. Again, all before they go into effect. Now, when we talk about, for example, the Sophie B Right case, that's what happened there. If you're familiar with the Sophie B Right case from back in May, where the students were involved allegedly in the water balloon fight,
Right.
and they were suspended and denied, all of their
Well,
graduation and prom activities.
graduation and
Right. So what happened there is the students were suspended, and they were given an opportunity to appeal their suspension after it had already been served.
right.
Hmm.
Right.
Right,
Right.
right. So,
Right.
so there was no due process.
No due process. Right. Right.
Needless to say, and so that was our, we represented the children in that lawsuit. That was our first argument: is that before that suspension went into effect,
Right.
that those parents had they should have been given an opportunity to appeal it first, right? So when you find out that your child has been subjected to any of these exclusionary practices, know that you have the right to challenge before it goes into effect. Know that you should receive the bases of the exclusionary practice before they go into effect. And all of that language should be incorporated in your student handbooks.
Student handbook.
Uh,
And if
yeah.
it's not, then what do parents or advocates need to do in terms of addressing that school about it?
Well, first, if it's not, you always still have the discipline statute, which again is Louisiana Revised Statute 17:416. Nearly all of the school handbooks in the city reference the discipline statute. They may even say for their discipline policy, we incorporate all of the rules that are under 17:416. Which is a lot of rules. But the student handbook is supposed to mirror the discipline process. At least it's supposed to mirror the state's discipline statute, that 17:416. If you have a school district that makes no reference in their handbook to 17:416 and has absolutely no discipline policy, then you need to contact the school and put them on alert that they are committing a due process violation within itself, right? Because you as a parent, have not been provided with notice of your rights, notice of, in the event this violation has occurred, notice of the basis of the violation, right? So if that exists, where there's absolutely a silent policy on suspensions and expulsions and transfers alternative schools, then we have a due process violation off top.
And can you give, so in New Orleans in particular, in this system of schools, we have a situation where that policy can change from charter management organization to the next. It can change from one school to the next. And with this, the structure of schools having autonomy and being able to determine a lot of these things, how do parents navigate a system where schools can kind of like make up their own set of disciplinary rules and practices? And if you can speak a little bit about like some of the things that you've seen that schools are doing as a normal practice that are actually not okay.
Yeah,
not legal.
Yeah, totally. So the first thing, the answer to your first question about, how do we account for the lack of uniformity? No policy is to exceed 17:416, right? And so, yes, each school can. We'll talk about in a little bit. They can. I don't want to use the term finagle. That's too cynical. Most schools can. Most schools can kind of, set their own policies, but or even circumvent, right? But none of the school's actions are supersede statute, right? And so it's basically like, think about 17:416 as a box. It's, you can do anything that happens inside of the box, but you can't you can't go outside of that box. Now it's a very broad and narrow and wide box at the same time.
Right.
But in terms of like due process rights, there's no superseding 17416. And so the rules that I just mentioned about having notice and an opportunity to be heard before it's being subjected to a discipline practice, that should apply for every single school. Now, what we have observed is the means and ways in which students are suspended and expelled can vary. A little bit about expulsions. Expulsions are still, they are still ultimately under the review of the school district under OPSB. So a charter school can make a recommendation for an expulsion, but that expulsion hearing still happens over at OPSB. Or NOLA Public Schools. Is that the new name, I think?
Right.
So having said that about expulsions, for every other practice, we've seen some interesting things here. There was one charter school in the city that did not allow students in if their tattoos were visibly showed. So aside from that being a First Amendment violation,
right.
You can't sequester student speech. That's an impermissible restraint on student speech, by the way. And that was actually written in their handbook. No visible tattoos. Cannot do that, folks. That is a First Amendment violation. But instead of suspending those students, they just wouldn't let them in, right? It's like, oh, if I see your tattoo, if I see your sleeve out, we just won't let you in. Well, that is considered a suspension. That school district attempted to argue that it was not. However, it is an exclusionary practice. That's why the term exclusionary practice is actually more accurate than, say, a suspension or expulsion, because it's any act. It's telling a child you cannot come in or you need to leave for any reason. That's why we say exclude, right? And so we've seen that. We've also seen the grooming policies, the hair policies, where, particularly, that particularly target Black female students, that if their hair isn't a certain way, that they are not able to enter school grounds, which, by the way, that also there's a couple of issues with that. The main issue is that is it's actually an ADA violation. It's a disability violation. A lot of folks don't know this. If you have a hair policy in place that creates no medical exceptions, think about the student who has alopecia. And alopecia is an autoimmune disease. That means it qualifies as a disability under Section 504. We know that a manifestation of alopecia is hair loss. Those students will oftentimes, in the moments that they have a flare-up, they may want to wear a wig to school. If you have a policy on the books that says no weaves, no wigs, no exceptions, which we have seen. We have seen.
No extensions.
Right. And literally the language, no exceptions afterwards, right? When you have that, that's a 504 ADA violation, And so we've had a student who has not been able to enter school because of that. We've also had a student who has been unable to enter school because they didn't have on a uniform. But the thing was, that student was homeless. And so that is considered a McKinney-Vento violation. A lot of families are actually unaware of this, that technically, schools are not allowed to charge you for uniforms. And so if you are, of a certain income level to where you can't afford a uniform, and you send your child to school without one, and the school sends you back home, that's a suspension, right? But also, that is a violation of the Every Student Succeeds Act, because schools are supposed to make it to where you cannot condition attendance on money. And so what is supposed to happen is schools are allowed to have a fee schedule. They can have this fee schedule of how much uniforms cost. but they should always have a reserve fund, or not even a reserve fund, an extra set of uniforms for students who have demonstrated financial need. And
Okay.
so if you cannot afford a uniform, the school has to give you one. But under no circumstances are they allowed to condition your attendance in classroom, your child's attendance in classroom, on whether or not they can afford to even have the uniform.
Right.
But we've gotten phone calls from a couple of charters in the city where parents were saying, you know, my child didn't have on the proper, emblem
Have
on
to
their
make
shirt.
notes.
And so we
Yeah.
got sent home, and then the question is, well, why don't you have the proper uniform? And then the answer is, well, we couldn't afford it. All right, so we got an ESSA violation, and we also have a unlawful suspension by
Mhm.
sending the child home.
Right.
Just
Well,
a few examples of the ways that um, well, buses. That's another one. You can't forget buses. Everybody knows the RTA is late.
oh,
Everybody knows that. I have never made it to anything on time if it is the RTA. No shade to the RTA,
right.
right? Like,
But I
it's
take
a
it when I'm
city
not
bus.
really trying to get anywhere.
Right, right, right. It's a city bus, and it's not even just the RTA. When I was in grad school and I used to take the public bus to school, I was always late. It's just a city thing, right?
Hey.
Well, for the school districts who do bus tokens, we've gotten phone calls from families who have naturally showed up to school late because they have taken public transportation. Maybe I think the cutoff is like 5 times.
Mhm.
And if the child is late 5 consecutive times, that they'll be suspended. That's in the school rules, is in the school handbook, right, for being late. Um, and so if that happens, that actually amounts to a bus suspension. A lot of schools will fashion it as just your regular run-of-the-mill discipline suspension. That is a suspension associated with busing.
Mhm.
That is also automatic grounds for a due process appeal.
Yeah.
You should have the right to appeal that. And in the hearing, if your basis is it's because we have no other transportation except for these bus tokens you get, then there's no reason why you shouldn't prevail in that hearing. But I basically am bringing up all these scenarios to say, you know, honestly, I mean, as a parent, I'll say just rely on for your parental instinct.
Yeah.
If it doesn't feel right, it's not right,
Yeah.
right? Or you should at least be able to inquire about it. So I tell parents just to be on the safe side because there are so many different ways that their children can be subjected to these practices that if there's any action taken by a school that results in your child not being able to be in their classroom, then count it as one of these disciplinary exclusionary practices and know that your due process rights, your notice, and your opportunity to be heard are automatically triggered.
Mhm.
And we have a document that I'll provide to Nahliah that basically walks you through the steps of what to do when your child has been suspended or expelled or even arrested or referred to law enforcement while on school grounds.
Right. Thank you. That's helpful. I do have a follow-up question though. Does this also pertain to instances of violence? Is it possible to just say, I saw you fighting or you brought a weapon, so that's an immediate and there is no due process? Or how does that work out?
So when it comes to weapons, you're still entitled to due process. However,
Mhm.
even fighting, however, the only exception is that the disciplinary action, and thank you for bringing that up, the disciplinary action can take place before the hearing. You see what I
Oh,
mean?
yeah.
Yeah, but
Yeah.
you still
Right.
have to have the hearing. You're
Okay.
still entitled to the hearing. So when you encounter, we've encountered families who, a student may have brought a weapon to school and was automatically expelled, right? Or suspended. Um, that's fine because the student brought a weapon, but that child is still permitted after being sent home. That child is still entitled to appeal whatever decision comes from it, whether it be a suspension long term or being sent to homebound instruction or being expelled. There's still an appeals process. It's just that schools, given like the exigent circumstances, are allowed to go ahead and
Right.
proceed with exclusionary practice before having that due process hearing. But the due
Mhm.
process hearing must still occur.
Okay, due process still applies there. And
Absolutely.
so a little sidebar, but I believe in 17 416 that this also applies to if you're a student that drives to school and there's something in your car and that car is on school property, um,
Yes.
a disciplinary action can still happen. So if you had a gun in your car and it's parked on campus, they can still say you
Mm-hmm.
brought a weapon to school.
Absolutely. Or illegal contraband. Yes, absolutely. Whether it be, I mean, we get this a lot with students who have marijuana in their car and they are, ultimately sent home. Now, I can't, this is like a whole nother topic within itself, but I'll briefly touch on it. There are some restrictions around like unwarranted student searches and
Mhm.
and
Yeah.
so, if that happens, if you have something in your car as a student and it's discovered and you are, subjected to some disciplinary practice as a result, make sure also that the issue of search and seizure is raised um, during that hearing.
Yeah.
Basically, you want to know under what circumstances did the school have permission to inspect your vehicle, because there are still some privacy rights
Mhm.
attached to students. Those rights are diminished, but they do still exist.
Right. I'm just writing down here privacy rights because I was thinking
Mhm.
people really kind of need to know in terms of the letter of the law where your privacy begins and ends. And it's not the school door, it's like the school parking lot, but it's also like buses and things like that. So I think
It's also, yep, it's en route to school. I forget the case law on whether it's from school. I think that does apply. It
Mhm.
also applies to any school sanctioned activity, like an extracurricular. Um, and again, the general rule is that the rights to students with regard to privacy are diminished but not eliminated. So there are still rights. We see this a lot in terms of locker room or locker searches.
Right.
There, in terms of like these, uh, randomized locker searches, there has to be some reasonable suspicion on the searching parties, and that there will be the discovery of some illegal contraband. It can't just be we're going to go do a random pat down and locker check, right? And so that's why I said, if you're in that situation where something is discovered, whether it be in your locker or whether it be in your vehicle, on school grounds, you do have the right as a part of your due process hearing and your due process rights to question the bases for the search to begin with.
Right. Right.
Mm.
Thank you for that. And I know you wanted to talk about the disciplinary statute in and of itself. Can you just and I know you mentioned it all the way through this conversation,
Yeah, I
but
kind of wove it in. Yeah.
and we had an intern this past summer actually comb through the whole thing. So we'll be
Oh, bless that
publishing.
person.
Hmm?
I said, bless that person.
We would have weekly check-ins and she's like, this document is wild.
It,
And I was in and she was like, first of all, you can't know all the things that are in this, but there's a lot in there about teachers, what teachers can and can't do, and administrators and the kind of latitude that they have. There's a
yes.
lot in there about parent behavior. I mean, in terms of there are consequences for parents doing or not doing a thing,
Mhm.
as well, and kind of using the lever of the parent to deny access of the child to the school.
That's right.
So we'll be breaking that down and publishing that on our website in the near future. But there's a lot in there. What are some of the highlights that parents just kind of like need to know or students need to know?
Okay.
That,
So on the subject of parents,
Mhm.
this isn't the proper term, but essentially what it is parents can be suspended. I mean, it's not called parental suspension, but parents can be prohibited from being on public school grounds for engaging in various activities, including, threatening a teacher, or being perceived as being like hostile or threatening to school faculty. In other words, being a substantial disruption to the learning environment. I
Mhm.
know that's an incredibly subjective term, I know that, depending on what teacher it is, it could mean something as simple as a parent disagreeing with you. And so
Right.
we often have issues in that area.
Mm,
But again, if for a lot of families, if you are telling the parent that they're unable to access school, then you're also telling the child that they're unable to access the school, particularly for small children, like elementary school students, right? And so we have, I will say, we've yet to have someone bring this up to us. It's not that it's not going on.
mhm,
It's just that we haven't had anyone bring this issue to us, and I'm a little surprised that they haven't.
mhm.
But I think the argument can be made very clearly, particularly on the elementary school level, that excluding a parent from entering school grounds can, in some ways, effectuate a suspension on the child.
Mhm.
I mean, think about the example of a kindergartner, right? If their parent is told that you cannot come to school because you've engaged in this particular activity that has disrupted the learning environment. Um, if that child's not taking the bus, then how are they going to get to school?
Or if the
Right.
parent needs to pick that child up for whatever reason,
Exactly.
how do they enter the
Exactly.
building to do
Yeah.
so?
And so hasn't become an issue yet, or it hasn't been flagged for us yet. But and maybe because parents don't know, right? Like again, maybe it's because it's like, all right, well, this happened and I made this teacher upset, and so I gotta find someone else to take my child to school. But I'd be yeah. Me myself, because I have no problem challenging these things. I would make the argument that that does result to the form of a student suspension.
It could
It's
be.
a barrier to access in the classroom.
Right, right. And what about some of these other policies where it's like if the parent doesn't come to the meeting, then a meeting to discuss the child's behavior or what took place, and your child cannot return until the parent shows up for the meeting, because that's a thing, right?
Hmm.
Right. We have a meeting that's set up to talk about what happened, and we have a mandatory meeting that needs to take place with the parent before we allow your child to come back. And if the
Hmm.
parent doesn't make that meeting, the child doesn't come back. That's in the statute, I believe. What about those kinds of things?
Yeah. So the definition of meeting is supposed to be incredibly, extremely relaxed,
Hmm.
to where it accommodates for any type of family. Meaning, if it needs to be a phone meeting, then
Hmm.
so be it. It
Okay.
doesn't have to be an in-person meeting. You will find schools that will make it to be an in-person meeting.
Yep.
Just know that as parents, you can challenge that. You don't have to show up in person. There's no rule that requires those meetings to occur in person. You have
Hmm.
to be able to, as a school district, accommodate for all of the different types of families that you're serving. And
Right.
so if that is a phone meeting, then so be it. Um, any type of communication between it could be a letter writing back and forth. I haven't seen it, but it could be, right? As
Yeah.
long as there is, as long as there's an opportunity for the school to notify the parents of the conditions under which their child can return, and the
Hmm.
parents can agree to those conditions, that constitutes a meeting.
Okay. That's good.
Hmm.
All right. Well, we are about the end of our time. We could go on and on.
I know this is an all day thing.
This is your all day, your all day life, like in
It
and
is.
out, right? And you're not just focused on what's happening in New Orleans. You guys are covering what's
Yeah,
happening
we're
across.
statewide.
Yeah.
Absolutely.
So, and I'm sure it looks different in different school districts, depending on
Yeah,
demographics, depending on resources, and just knowledge and culture, right?
that's right. That's right. Yeah.
So you're fighting a multi-fronted battle here. So I thank you. I thank you for your work. I thank you for coming through and just sharing this with us. I took a lot of notes during this conversation because there's so much to highlight and make
Hmm.
plain for parents, from the silent forms of suspension. I like that language. We start using it from now on. But it seems like the most important parts are due process. People just can't send your child. Your child is entitled to a free and appropriate public education, and no one can just send your child out of that without
That's right.
being a proper professional process that where you're made aware of what's going on and you have the opportunity to speak for your child. So if there's anything that you take away from this webinar, whoever's viewing it, just know those two things. And if you're helping or supporting another family that's going through this, just bring those two pieces of information to them. They have a right to know what's going on, and they have a right to speak on it and advocate for their child. We will, again, we'll have this document where we try to break down the Louisiana Discipline Code. And, you know, there's going to be some work, I believe, probably in the next legislative session where they may try to, again, address the discipline code. Do you think?
Have you talked to Gina yet? I mean, we're just going to take a collective side. And
a collective side.
Is we will try.
Yes, yes. I mean, because the code is not in itself, it's not a perfect code. There's a lot of room for inequities to happen there.
Yes.
So it's not a perfect code, but it's what we have. And there are organizers on the ground that are trying to change it, but that's a hard fight. And so hopefully we'll see it again in the legislative session being tackled there. But thank you again very much, Victor, for joining us. I'm also going to make sure that folks have access to, or at least know where to find the Know Your Rights document that Southern Poverty Law Center has on their website, as well as some of the other resources that you named. So thank you again. Thanks for being in this fight. And we're still going to keep referring a lot of people to you.
Sounds good. Have a great week.
All right. Thank you. Have a good day. Bye, Victor.
Thank you. Bye.